need a little bit of time.
You know what? The devil created me, and I know that. You
I don't
are
believe that for a second.
trespassing my creation, my creator's creation. So fuck you.
Oh, okay, thank you, Mr. Mill.
Faxing it to a certain person is not a good excuse, Judge. He's sitting there waiting 14 days just because somebody didn't do their job. That should not fall on him and cost him 5 extra days. That's 5 days this man is sitting in jail. 5 extra days.
Very quickly. This is 2529290. Here's my issue with this case, Judge. Mr. Perez posted a $1,000 cash bond. Upon posting the cash bond, he went to ICE custody. He's in ICE custody. He's already been removed before. All they do is reinstate the order. He's waiting for a seat on the plane. Now,
You have proof that he's actually in custody that you can show me?
yes, on Monday. Well, I can pull it up right now, but on Monday I can.
There's no sense in waiting till Monday. If we know what's going to happen now, there's just no sense in waiting until Monday. We can take care of what we need to do now.
But here was my question. If this court is inclined to revoke based on being in ICE custody or the bond condition violation, I was going to ask for a court reporter because I think it's a good issue for our appellate division. I've talked to the division. I don't think an involuntary violation is a basis for a revocation. But aside from that, he told me to avoid all that legal issues, he'd rather plead a time served.
But I got to get him back.
I can get him on video on Monday.
No, but we need thumbprints. We need signatures. We can never do a plea remotely. They have to be here. What I can do, no. I know, no, but I'm not. I need his thumbprint. I need his signature on the plea paperwork because we can't do that remotely.
Okay.
I can bench warrant him here and we can get him back.
I don't see a basis for the bench warrant, Judge. Bench warrant's got to be he violated a court order. I don't, if he's going to.
Telling you that to help you to bring him back.
No, I understand. If you bench warrant him, he's coming back. He doesn't come back.
He doesn't want to take care of this? Because I'm telling you, if he ever wants to come back to the United States, it's going to be such a problem for him.
Judge, there are some people, look, I can tell you in the federal context, right? If you have a defendant charged with 1326, 8 U.S. Code, illegal reentry, and they could be deported rather than face that conviction, they're going to always choose deportation because there are some people that are screwed immigration-wise. This is one particular individual. He's screwed immigration-wise. I've advised him of consequences. He wants to be home for the holidays. Okay? I understand.
So short-sighted, you know, really.
In terms of what? Immigration law, he's permanent barred. I mean, run you through all the sections of the INA. He has no options to get anything anytime at any point in the future. So he wants, it's a waste of taxpayer money, in my opinion. To bench warrant him, Harris County has to go all the way up there to Conroe, or I think they go to Greens Road. Federal government brings them down to Greens Road.
Here's the thing. I think it would be unreasonable if he gets deported for me to continue to reset this case. Because that's what you're asking me to do. I indefinitely reset this case.
Well, what I'm asking, look, your docket management issues, that's a docket management problem. But the DA's office, if you look at their dismissal form, one of the boxes is deported. They can always refile the case. That's a docket management issue that they can take care of. But for him to
can't always refile it because they have a statute of limitations.
Well, you know, issue, but I don't see what the basis is to revoke bond off an involuntary violation.
I agree with you.
So where's the? I mean,
but I cannot indefinitely reset the case.
Then what's going to happen?
I don't know. Let's see what they want to do. Perhaps they'll dismiss it. I don't know. Have you spoken to them about that yet?
Yes, they did not want to dismiss it.
Okay,
they offered the time served.
And if he ends up getting deported, right?
But here's the thing: if you revoke bond on Monday, he's not going to get deported because ICE, every time they're about to deport, they do the warrant check. They're going to see the revocation, and they're going to bring him back here, and it's probably going to delay everything, maybe 4 or 5 weeks. Cost the federal government money, cost the county money.
Okay with that. He has plenty of money, and it's better in the long run for everybody if we get it back, take care of things the way that they should, as opposed to the other way.
And Judge, I have 2 follow-up questions, which is then one on Monday, I would like a court reporter for the hearing because we're going to appeal that up. And the second thing is, would you agree to reinstate because he paid the cash bond? He doesn't want to lose $1,000.
State, need your help, if you don't mind, please. So we're in a bit of a conundrum.
We talked about this a little bit.
I just forgot the cost number. 1 second.
Judge.
Oh, don't worry about it. Look, hey, don't worry about it. You ready?
Yes, sir.
Okay, Mr. Perez, he has a prior assault, looks like it was disposed in 21. Is that a conviction?
He has one prior conviction, Judge.
Oof,
With the
Yeah.
affirmative family finding.
finding, right. So
2021.
he's got that prior, picks up, I guess, a felony assault in 23 that gets dismissed,
Right,
a felony theft that's also dismissed,
right.
and then now he's picked up a DWI, Class A. And I guess what happened was they give him a PR bond, like they do, I guess, on every case, and then he ends up going to ICE.
Well, Judge, let me clarify. We actually approached for a PR bond. This court didn't want to give him a PR bond. He had a $1,000 bond. I told him, so this is on me because I didn't read the bond conditions beforehand, but I told him that if he paid the $1,000 bond because he wasn't set until January 7th, knowing immigration, there was a likelihood he was going to be reinstated and deported before January 7th. But the bond violation report was filed because he failed to get an interlock and he failed to report to pretrial. That was an oversight on my part to not look at those conditions. I mean,
It's not a deal.
I hear you.
I'm never going to ding someone for.
no, I'll self-ding. I've already done myself.
But, so what he's asking for is he's asking, you know, are you going to dismiss? These are hypothetical questions. Are you going to dismiss? If not, how do we go forward? Because he's in custody, he's telling me that he's probably going to end up getting deported because he's been removed already once.
I know he's getting deported. I spoke to ICE yesterday. He's awaiting a seat on the airplane.
So they're going to, the problem is that basically what he's asking me to do is not revoke his bond and just let it continue, right?
That's correct, Judge.
That means I would really be indefinitely resetting this case because he'd be getting deported back to his country. And I would literally have a case on my docket for the next 30, 40 years or however long until he comes back, if he comes back, right? And I think that's a little unreasonable, right? So what I suggested is that we bench warrant him back here so we can take care of the case one way or the other, whether you guys dismiss it, whether he pleads somehow. In the alternative, I could issue a warrant for his arrest, right? And then that would also be a way that we could get him back here. I think that you're opposed to both of those methods.
That's correct, Judge. I don't think there's a basis in the code for either method.
And we spoke,
So look, don't respond yet. Let's have a hearing on Monday so that everybody here can properly research, is that a proper way for a bond revocation, right? Can we revoke the bond? Is it a proper revocation or not? I don't want you to answer now, but take time. Let's look over it, you know. I don't do anything that's wrong, right? I never, ever. I think it's just holding this case open indefinitely. I do that, man.
It's a conundrum, Judge. I mean, I think this, there's bond amount that can assure he would appear in the future, right? Even in $1 million bond, right? So, but at the same time, you can't hold a Class A at no bond. You know, I mean,
No one's holding him at no bond.
right, but that would be the only alternative. In the case you revoke bond, let's say you revoke bond on Monday, he's back in Harris County custody on Friday.
That's not necessarily true. They may deport him anyways. We have dozens of cases where they've deported him regardless.
I can tell you that in my experience, when ICE does the deportation, they do a warrant check. They'll deport pending charge, they'll deport. But if there's a warrant, if there's a revocation, they will send back to Harris County. That's my
I've seen it
experience.
both ways. It's discretion.
If there's a capious.
So, but let's regroup Monday. I mean, how do we move forward? Do we revoke? Do we leave open? Do you guys dismiss? Do you have enough evidence? Can you eval the case if you don't mind? Is it a good case for trial? Is it not? I don't know. But let's regroup on Monday and see how we go forward.
And
You know?
the court reporter on Monday?
Yeah, Ramona, are you gonna be here on Monday? No, she'll be here.
Okay.
Yeah.
Appreciate it.
Mr. Caceres, you are in front of us now because you have a fugitive case. You are wanted out of state of Connecticut for sexual assault. And he is already waived.
Yes, Judge.
And where are we at now?
So, Judge, this was originally set today, but on Friday, on a notification from the demanding jurisdiction, they requested an extension from today to the 3rd. They didn't receive notice, which
Oh,
I don't believe this was addressed on Friday, but they've since corrected the issue with the original fax number not reaching the detective's desk for extradition. And so they've now corrected it where this won't happen again.
So are you saying that Harris County did not fax Connecticut?
No, they did fax Connecticut, but the fax numbers that they sent it to is it has to go through, I can't remember if the name is inspector or adjuster, but there is a figurehead that has to flow through before it reaches the detective's desk, the actual extradition detective. And so on the third attempt, when there was no response, is our sheriff's office reached out to their sheriff's office and finally got someone on the phone. When they were notified that same day, within, I would assume, a couple of hours, because it was still the morning, the detective immediately called Amy, who then notified me, and I talked to the detective within hours of being notified. And from then, they asked an extension to the 3rd to pick him up. For this offense, they have been investigating since 2021, and the warrant issued in 2022 is that they've been pursuing this defendant for quite a long time. And again, this was learned after our approach. I'm speaking with the detective, is that they weren't aware, they had a possible suspicion he might be in Texas, but they weren't even aware he was here. But due to the severity, the nature of the offense, where, to recap Friday, is that this was closer to a burglary of habitation, 1st degree, where sexual assault was committed after forcing himself into the home of someone that he knew. This was not from what they allege, it's not a dating relationship, but someone he's familiar with, is that because of the severity of the offense and the fact that the warrant is so old, is that the detectives believe they are not confident that he will self-surrender. And because they've already confirmed, and they sent another confirmation email this morning that they are able to secure and pick him up this Friday, is that we request no bond for this offense and the extension.
If I may, so whatever the charges might be, it could be murder. It can't be murder because you can't let him out on
Right.
bond. The point is, he's presumed innocent. So without anything else, he is innocent as he stands here. No evidence is being presented. So if we're talking about the severity of something, he is presumed innocent. He is innocent of that as of right now. Until he gets over there to that jurisdiction, can they find him guilty of that? So presuming he's innocent, talking about the severity of a charge doesn't really have an effect on this fugitive case, because there are 2 things that he's got in place, 2 things that he needs to make a decision on, whether to waive or whether to fight formally his extradition. The waiver says, what he agreed to says, they have 14 days. It is ordered for the sheriff to hold him for no more than 14 days of the date this was signed. This is the actual order signed by the court. This is what he agreed to. Signed by him, signed by you, the judge. And so this is the agreement. The fact that somebody didn't send a fax to the correct number, that's not, it doesn't say, but if we send the fax to the wrong number, you get to hold them for 3 extra days. This says 14 days. This is what he signed up for. This is what's ordered.
The hearing then shifted to an extradition case, where the judge reminded everyone that an accusation is not a conviction. Even while considering public safety and flight risk, the court emphasized the legal presumption of innocence and explained how extradition deadlines actually work.
This is what I say should stand, and this is what I say should allow him to get out today. If they didn't do their due diligence for this, it's not on my client. He signed up for this.
So let me explain to you how things work, Mr. Caceres, is that the 14 days is a courtesy. Statutorily, by statute, we can hold you for 30 days. Normally, and it has become custom that we do 14 days because of the overcrowding that we have in Harris County. We have so many people in custody, 8,000, 9,000, up to 10,000 people at any given time in and out of our jails. And because of that, as a courtesy, we do 14 days. Now, many times I grant extensions, I don't grant extensions. A lot of times there are several factors that is determinant of whether I grant an extension or not. One of the things are, has there ever been an extension before? Number 2, the nature of the charge. Number 3, have you ever had a fugitive case before? And so these are things that I look at as to whether to grant an extension or not.
Your Honor, may I please speak?
Well, I don't know. You may want to talk to your lawyer. The thing is this, look, I don't want you to talk about the original case. Okay, because the thing is that I live stream these proceedings, right? And so I don't want you to say something that will, you put your foot into your mouth, because here, the only thing that we're discussing is whether I should set a bond for you to get out, for you to go turn yourself in. That warrant, even if I let you out today, that warrant will eternally be there, and it'll always be out there until you go turn yourself in. The only thing we're discussing now is whether I should set a bond to let you go turn yourself in. And I don't know, because are you a flight risk? I don't know. The only thing I know is that you're charged with a very serious case. It's sexual assault. And so to me, the protection of my community is paramount, number one. Number two, the other question I have is, if we let you out, are you going to go turn yourself in? Everyone tells me that they're going to go
I
do
have
that.
my family sitting in court, and they are the one, they're the one supporting me. And I know 100% they're going to support me to turn myself in. That's why they're still here, and I'm still the last one. And yes, I didn't know about the fugitive warrant that I had. And yes, I'm willing to turn myself in because I'm innocent.
You need to fight those charges regardless, because they're very serious charges. So Day, what day did you say that they're going to pick?
It's Friday, and I forgot to include, I know typically the court permits over objection for the 3 days, but considering the New Year's Eve is holiday, that's how I also included the.
So are they going to be here Thursday and we reset to Friday?
On Friday. And so that's why the discussion on last Friday was having it on the 6th, but if they're not here by Friday morning, is that you would potentially grant a bond.
So this is what we had planned to do, was I was going to give them an extension until Friday morning, right? If they don't come by Friday in the morning, I'm giving you a PR bond.
John, I came to visit my family for the holidays. I wasn't able to enjoy that. I'm willing to turn myself in, but I would like to be with my family for the New Year's to start with a strong
concern is not my concern, and my only concern is I want you to get back to Connecticut.
And I will, but I need my family. I need to today, as the paper says, I signed for 14 days, and I would like to have a time with my family to look for the bond, to look for them to go forward with turning myself into Connecticut, but not like waiting for Friday.
Let me make one thing clear to you. This isn't about giving you a PR bond. If I were to set you a bond now, it's going to be something substantial, meaning a high bond into the 5 digits to ensure that you go back to Connecticut. This isn't about giving you a PR bond. If they fail to get you by Friday, I'm going to give you a PR bond, because they have fallen on their word twice, and I'm not going to do it. Now, if I were to set you a bond now, I mean, it's over 10,000, something like that, to that nature. And because it's a fugitive case, there's no 10%. You're probably going to have to pony up 90 to 100% of it, because you are an inherent flight risk, because it's a fugitive case. So there's none of this 10% where you pay $1,000 and you're going to get out. No. In these types of cases, when we have fugitive cases, I normally set bonds, 5,000, 10,000. I've set bonds at 50,000. I've set a bond at 100,000, depending on the nature, severity, how many criminal history. So this isn't about just letting you out now willy-nilly. No, I would set you a bond, and it's going to be a substantial bond, because I have to know if I'm going to let you out, there's got to be enough blood in there that you're going to actually go back and not just try to flake out. Because if you take off and you don't come back, all that money's gone. So,
okay. But the 14 days were exactly what I signed for.
Remember, it is a courtesy. Statutorily, we can hold you here 30 days. Okay.
To address the legal part of it, if your client is stating that he is withdrawing the waiver after today, then at that point, if you're considering a refusal, then we'll start the governor's warrant process and we'll hold him to 90 days. So if that's what your client is requesting, just in terms of your argument, because you were stating 14 days, that's true. If you want to at the end, then revoke it, then we'll request an extension to 90 days and get the governor's warrant. So.
Judge, my argument is what he signed, what the order states, and the documents filed in this case. This is what's filed in.
I get it. I understand that. But you know, there's sometimes extenuating circumstances, things happen.
Not faxing it to a certain person is not a good excuse, Judge. He's sitting there waiting 14 days just because somebody didn't do their job. That should not fall on him and cost him 5 extra days. That's 5 days this man is sitting in jail. 5 extra days just because somebody didn't send a fax to the correct person. This isn't the first time.
It's a courtesy.
I get it. Okay.
We can hold you 30 days. The 14 days, I don't have to give anyone 14 days. I can hold everyone 30 days if I wanted to. 14 is a courtesy. I've told you now that I'm going to give them until Friday. If they don't come here Friday morning, I'm letting you out. And now it's on them. And I don't care. I'm going to give you a free bond on Friday if they don't come pick you up. But if I'm going to set you a bond now, the first thing that's going to happen is you have to withdraw your waiver. All the 14 days that you've accrued so far goes out the window. You lose all the time that you've accrued. If you're unable to make the bond, you've lost all that time. Then they're going to get another, another couple weeks to come get you. So give it till Friday. If they're not here, then I'll give you a PR bond. If they come here by that time, then you get up and you go fight the charges in Connecticut. Now, when you get to Connecticut, you can also, ask for a bond there. They can set you a bond there. But, the money that you would spend here just to get out, it's probably, use that to hire yourself a great lawyer there. Because the thing is that here, it's just a little wait. That in Connecticut, that's what you really got to worry about. This is peanuts. You go there, lean on your family to get you the best lawyer you can get in Connecticut so you can fight that case. That's where the concern should lie.
Thank you, Your Honor.
Remember, when you get on that phone in the jail, every phone call is recorded. Be careful what you say. Be careful who you talk to. There's a lot of jailhouse lawyers over there. They're going to tell you this, they're going to tell you that. Listen to Ricardo. He's going to direct you the best. And then we'll reset this to Friday. If they don't come Friday, I'm giving them a PR bond, and I don't give them.
Right, I'm with you, but it was remember, because the holdover issue is that it has to be set.
We'll set it to Monday.
Right.
But
otherwise he's going to be brought up in.
You'll be here Friday, right? Okay, we'll look in the system if they've come get you Friday morning. If not, if they haven't come get you, we got to set a time.
What time? Actually, they emailed confirming. Let me see if I can get a time, because they have to send it to Central Records for the pickup. So I'll see if they're able to
We brought you here today so that you could hear what's going on, because we wanted to keep you in the loop so you know what's going on.
Thank you, Your Honor.
Okay, that's why we brought you here today, so you can hear, so you're in the know, because this is your case. You need to know what's happening.
Hopefully they'll respond soon. I just emailed the inspector over there. So it is inspector. And so hopefully he'll get back to me soon. And then
We can roll it to tomorrow. That way gives you a little bit more time to get a concrete and firm time.
I have the date, right? If it's just the time, I mean, I have no issue with rolling it just to check the time, but every day that rolls over, he has to get brought up in the morning really early. So
what I want to do is I want to be able to commit them to a specific time on Friday. So I know I can start working on a PR bond, because I'm not giving them until 5 p.m. Friday. It's got to be in the morning, and they got to come get you. And if they don't by 10:30, then at that point I start working the PR bond for you.
Why don't we just set it for 10:30?
I mean, if I get a different time, then obviously I'll email you and I'll email the court. And so
it's got to be something reasonable, morning-ish.
I think they indicated morning, but obviously until they confirm with our Central Records.
I want to know from them specifically so that they can say, "Oh man, you didn't tell us the time." And no.
Right. I think I only had one first specific request for an
I
afternoon.
want them to commit so that they know if they're not here by that time, he's going bye-bye.
The only concern would be is if we don't do it by the time court is done with.
That's why I'm trying to commit them to a time before court is done, so that they can't.
Perfect.
It's on them. And there's no one else that they can blame.
Okay.
We can bring them back tomorrow if you want to do maybe we're off Wednesday, right?
Yes, Judge.
Thursday, whatever you want, or we can email and then you can,
We could email and just, unless they wants to.
Well, I'm emailing the detective now because I emailed the inspector originally. I probably
they
should.
may not respond within,
Well, we could approach on it tomorrow.
Yeah,
off
of course.
docket. We don't need to bring Mr.
That's what I mean. Is
done.
Yeah.
That's what we're doing. We're gonna pick a time Friday for them to come pick you up so that they are in agreement with. So if they don't come here by that time, you're giving a PR bond.
Thank you so much.
Okay? Okay, man.
Thank you.
Okay. Thank you, Judge.
All right. You're on bond for a case with us, and you've now picked up a new case. Your bond now gets revoked. He goes with you? No, sir. We'll appoint him a lawyer today. Thank you so much for coming. Are you Mr. Pearson's mom? Okay. So is he working? Tell me about him.
Yes, he's working on it. In a political life. He's in big trouble with me because I had him to do a voluntary repo on the sports car because he's not mature enough for it. He still goes.
They took the sports car.
I had him to do a voluntary repo.
Wow.
There's consequences when you don't abide.
You're my hero.
Um,
Really. That's great. Mr. Pearson. She's great. You got to listen.
I made sure I enrolled him in the College of Maine. I go to College of Maine. I just graduated last May. This
Wonderful.
past May in cybersecurity. I'm an IT.
Great.
So he knows the rules.
Okay. I'll give you guys a lawyer, whatever you need,
I was gonna talk to you about what you can do for his first offense on this and get it over.
I can't. So let's do this. I'll provide you the lawyer. The lawyer can tell you how to move forward with dealing with the DAs, but I can't get involved at this point just because I can get in trouble for doing that. So let's do this. I need you guys, let me see if I have an application on file. If you don't mind, I need you to fill out an application for me. Once you're done, I'll give you guys a lawyer and then you guys can work on the situation. Do you see whether he has a license to drive or no?
He has one. He has one.
It was,
Okay.
he does have one, Judge.
Great. As long as you have insurance as well, then you can continue to drive. Just be careful how you drive.
He's in my old hoopty now.
Okay, great. Okay, guys, if you want to go with Stephen, he'll take care of you guys and we'll have you sign a reset. Thank you so much for coming, man. How are you, man?
Good, thank you. Later birthday, I understand. What'd you turn, 41?
That's cute. It's like I have hair.
I know
Let me do
you're
the
real
same now.
busy, so I'm not gonna take much of your time. We have two cases, Judge.
Okay.
On Montoya Carrasco, first name Franklin, I just got appointed.
Are these in custody or on bond? Okay, so Carrasco,
To make it easy for you, he's got an immigration hold.
Okay, sorry, I was making a note. Which one are we starting with?
Montoya.
Montoya. Okay.
That's the easier one.
Yes.
wait, we're talking about, okay, Montoya.
Cause number,
I got it. So it looks like she's got an ice hold, huh?
yes, Your Honor.
So whatever you want.
I need some time.
Of course,
I understand they told me 10
however much time you need.
Okay, all righty.
Who's two?
This is assigned to, wait, sorry, what was your question, Judge?
A little bit over a month.
No. You said you have a second person, right?
Second one, okay.
Who's the second one? I don't care however much time.
Okay. The other one is a unusual case. It's the first case I've ever had in my life. Last name is Oriana Carranza. Is that the one?
Yeah.
What's so unusual?
One of them is for, that one for bail hearing, Judge. I don't know if you got the paperwork.
No, not yet, but, so it looks like this gentleman also has an ice hold as well. So whatever you want, however much time you need, it's whatever you want.
Okay.
Just,
And I got 30 days for him, but
Okay, sure.
I needed a bail, lower the bail. The bail is $2,501. He has no criminal record. the harassment between you and I, it's allegedly threatened.
From immigration holds to extradition requests, this hearing showed how courts balance individual rights with public safety and courtroom procedure. Every decision required careful legal reasoning, not quick conclusions.